Hi everyone, my name is Jannette Shockley. I am a partner with Lazega Johanson and manage our association collections practice. In this video, I will discuss one of the most important collection tools, the association's lien, what it includes, how you secure it, and how it benefits the association, even when an owner files bankruptcy. First off, what is a lien? A lien is really just a piece of paper that says that someone owes the association money. It generally looks like this. This piece of paper is filed in the county records, so the whole world is on notice of the amount owed. Good title to the property can't be given until the lien is paid. How the lien is secured to the property depends on your association type. Some associations have an automatic statutory lien, while others must file a paper lien in the county records. I usually file a paper lien in the county records for all my associations with an automatic statutory lien because it makes it easier for closing attorneys to find the debt and get the association paid faster. Many boards ask me about what charges are included in the association's lien. Liens usually cover all unpaid assessments, fines, late fees, interest, and costs of collection, including attorney's fees and costs actually incurred. An association's ability to recover certain charges like late fees and interest depends on the language in the covenants. Good language for late fees provides a cap or specific calculation for determining the amount of a late fee. Bad language provides that late fees are solely determined by the board. If you have bad language, you unfortunately can't charge late fees. Depending on your association type, the interest that you can charge may vary as well. Most associations default to interest rates of 7% or 10% per annum unless a higher rate is specified in your documents. We can review the late fees and interest language to make sure that you are charging the right amounts. If your documents have bad language, we can work with you on an amendment to fix those issues. Now that you know what a lien is and what it includes, the next question that I am usually asked is how long does the lien last? Liens are good for 4 years, so they do not last forever. The law encourages you to act on your rights before your lien expires by filing a lawsuit against the owner. When you file suit and obtain a judgment, you are entitled to a different type of lien, known as a judgment lien, or writ of fieri facias, a FIFA for short. A FIFA lasts for 7 years and can be renewed perpetually. By filing suit and obtaining a FIFA, you end up dramatically extending the life of your lien. Next and most importantly, how do liens help when an owner files bankruptcy? You may have previously experienced the frustration of an owner filing bankruptcy and hearing that you can no longer collect anything from the owner personally. One of my associations had an owner, let's call her Jane Smith, who had not paid in nearly a decade and owed the association over $10,000. I filed a lien against Ms. Smith's property, later filed suit, and obtained a judgment against her. Ms. Smith then filed for Chapter 7 bankruptcy and received a discharge. She thought she had successfully avoided the debt to the association. A year later, however, Ms. Smith wanted to refinance her home. She was very unhappy to learn from her bank that the association's lien had survived her bankruptcy discharge and that she could not refinance without first paying the lien off. Ms. Smith ended up paying the association the $10,000 that was discharged to have the lien released. The board was very thankful that they had filed a lien and were able to collect in the end. As you can see from this client's experience, liens can make a world of difference. So make sure that you know your lien rights and how to use them for your community's financial success.